the requirement of 179C of continuous existence of confidence in that office. And, my lord, the flow test achieves both the purposes. The confidence in the leader of the house and the chief minister and the government, and the confidence in the office of the speaker also simultaneously. So two orders were passed by your lordship, my lord. The first order on 27th of June 2022, giving time of 2 weeks to file reply to the show cause notice issued by the deputy speaker, was nothing but compliance with the principles of natural justice, because 2 days notice was given when the requirement under the rules is at least 7 days notice. Lordship may just make a note. I'm only on the broader submission and prima facie case. What is the nature and scope of the order which your lordship passed? So, my lord, on 21st of June, there is lack of confidence in the deputy speaker. Deputy Speaker has issued a show cause notice giving 2 days when the rules require minimum of 7 days. A writ petition is filed, and in the writ petition, your lordship passed an order on 27th of July by just seeking compliance with the principles of natural justice, not restricting any authority to not to discharge. That, my lord, utmost respect, my lord. A confusion is sought to be created, as in the order of 27th of July, some kind of a curtailment of jurisdiction of any authority. Kindly have a look. I'm not reading, my lord. Kindly have a look at the second last paragraph of the 27th of June order, my lord. I'm sorry, 27th of June order, which only makes available period of 2 weeks time to respond to the show cause notice given by the deputy speaker. Number 4, my lord. The non-existent assumption on the part of the other side, no matter what reply you could have given, you are to be treated as disqualified on the issue of notice itself. The lack of confidence in the office of the deputy speaker further gets strengthened by such kind of a contention that no matter what your reply could have been, you were deemed to be disqualified the day when they are representing your lordship should be treated as disqualified. Now, my lord, kindly come to the document in volume 1 at page 82, my lord, which are the 1968 symbol order, only 2 submissions on that. My lord, the political party is not defined in the 10th schedule. Political party is defined in the 1968 order, your lordship has seen. But before that, my lord, differences and dissent, which your lordships have observed on so many times, is a part of democracy in every sphere. Differences and dissent is also an essential part of intra-party democracy. The recognition, acknowledgement, and incorporation of that intra-party democracy, my lord, and differences and dissent is, my lord, in clause 15 of the order. Kindly have a look before I go to that. Page 82, my lord, of this document, which is the symbol order. Volume 1, my lord, of the documents on the file R4. The third, madam lord, whereas it is necessary and expedient to provide. And last line, my lord, recognition of political parties in relation thereto and matters connected therewith. So free. A very important, significant aspect of that is recognize political parties and the matters in connection therewith. Now, kindly come to the next page. Subclause H. Political party. And political party defined here because of the plenary jurisdiction to be conferred upon the Election Commission of India on the recognition and incorporation of the principle of intra-party democracy, clause 15. Number of political party means an association or body of individual citizens of India registered with the commission as a political party under section 29A of the Representation of People Act. Now, my lord, various powers have been conferred upon the Election Commission starting from clause 14. Kindly have a look at that, my lord, page 91. Clause 14. Page 91. Clause 14. you see, my lord, the width and the plenary jurisdiction of the Election Commission, and it is all under 324 for conduct of free and fair election, where dissent differences even within the political party in the hallmark. Kindly have a look at that, clause 14. Power of commission to issue instructions to unrecognized political parties. So that also in the concern of the constitution makers, and then culminating into 1968 order, an important feature. Even a non-recognized, unregistered political party. 15, my lord, I would like to read, but before that, kindly have 16. So when, my lord, the split and merger, my lord, there are two different clauses in clause 7, we deal with split, and merger is 4. That split and merger was originally a part of 15. And my lord also dealt with in clause 16. Kindly have a look at clause 16. Power of commission in case of amalgamation of two or more political parties. And then 16A, power of commission to suspend or withdraw recognition of a recognized political party. So, my lord, absolutely plenary jurisdiction. Now, kindly permit me to read 15 once again, my lord, at the cost of repetition. Power of commission in relation to splinter groups or rival sections of a recognized political party. When the commission is satisfied, and kindly see, my lord, it can be on its own motor knowledge of the commission itself. It can come on an application, because the word used are on information in its possession. It can come from any source. It is only signify the importance of this aspect for the free and fair conduct of election. In possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. I pause here for a moment. As my other friend pointed out, my lord, in clause 3 we stand withdrawn from the attention schedule. On clause 4 we still continues to remain there. The concern is only with regard to number in the legislative party. It has nothing to do with the political party. Clause 2(1)(a) and 2(1)(b) that you are defining the directions of a political party, or you have voluntarily given up the political party, can apply, my lord, without the involvement of election commission if there is no cloud on who the political party is. The moment the question arises, who is the leader or who is the political party, as the surgically says, you travel to 15 of the 68 order, total exclusive jurisdiction of the Election Commission of India. So kindly see 15, my lord, which I just complete, and then go straight to the 10th schedule. The commission may, after taking into account all the available facts and the circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, kindly mark the next word, my lord. Decide. So for the purposes of 2(1)(a), political party, there is a question mark, the decision has to come from here, not from the office holder. Decide.
The issue is not so much whether the election commission has the power or not. What they argue is the batting order, which should be decided first. But the question is, would that arise in a context where the channels are completely different and the process and the method and authorities are all different? But are there any cases where the issue relating to anti-defection as well as matters relating to party determination have been commonly taken up, not episodically, but at the same time?
I'll just check up, I'll confirm it, but I'll come back to what you
lagging this.
Please permit me, I have understood, my lord, I'll see. But I'm coming to your actions are putting it. I'm sorry.
Yes.
Lord, your lordships are putting it to me that in which order these two issues to be decided, because let us assume that the two issues does arise. that who is the leader of the party and whether that incident of disqualification has taken place or not. If these two issues are to be decided, it must be decided first. That's what your lordship wanted to know. My respectful submission is this. I will go to straight away to 1A and to 1B of the 10th schedule in a moment. But what I was reading here is the decision who is the political party, who is the leadership, who has to give direction on behalf of the party, in the name of the party. That decision can only come from 15. Now I'm not only see the 10 sheet, but before that, kindly come to page 8 and page 10 of this compilation one. Because if this is the position, my lord, taken on oath before this honorable court, where the writ petitions are filed on daily basis on every event taking place, after this position is taken up by the other side before this honorable court, ground D, my lord, I want to read only 4 lines and ground next page, page 10. Para 36. Then, my lord, therefore, a contradictory position by filing a writ petition would not have been agitated, and that is the reason why no writ petition, quali election commission jurisdiction or election commission proceeding is not filed.
Ground D where?
Ground D at page 8.
And this is
ground. That pages are at the bottom. On the top, there is some page 38, but the running page of this compilation is page 8 and page 10.
This ground D, Mr. Maninder saying, this ground
isn't the writ petition.
Part of the writ petition.
Writ petition filed by them. No, my lord, your lordship must know, my lord, that on every event taking place after the floor test, they were filing writ petition. They have taken this position in this writ petition, but there is no question of jurisdiction or proceeding further of the election commission. And they have taken this position. Kindly permit me, the last 5 lines in para D. Who is the Shiv Sena? Who is the Shiv Sena? The moment this question comes, my lord, it is also our common case. Exclusive jurisdiction is of the Election Commission of India. And they said so. And once they said so, my lord, there was no occasion for them to file any substantive writ petition questioning that position, because they can't live with the inherent contradiction in their stand. Now, my lord, if that is the position, will your lordship permit an interim application to be filed in some other writ petition? Kindly see who is the Shiv Sena. That is the domain of Election Commission. Admittedly, recognition of Shiv Sena and leadership by so and so has been endorsed by the Election Commission, and there is no dispute. Now, kindly see para 36, page 10, next page. This is a part of the rejoinder, para 36. After our stand was filed to this writ petition, the file the rejoinder. So, original position is the moment question arises, who Shiv Sena? Election Commission. See 36, third line. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the first place. Why? What did I came for? I came for extension of time, which is in violation of the rules. Only 2 days, and I asked for 2 weeks. 2 weeks is granted by your lordship. Compliance of natural justice. That has nothing to do with either the office of the Speaker or the Election Commission of India.
All right, Mr. Maninder. Yes.
Only 2 minutes. Kindly come to 2. Kindly come to 2, but not the 10 schedule. 10 schedule. Only about 2 minutes and I am done. All judgments are cited. But I have nothing for this hearing. But kindly come to 2-1. There is no political.
Mr. Maninder saying it is read and re-read and re-read.
Only 1 minute I will take. You're not.
Otherwise, we will have to hear Mr.
I will just clear it in 1 minute. 2-1A. 2-1A and 2-1B. The last word of political party, and in the contrast in clause 3.2, which is deleted, and clause 4.2 of the merger and the split, it's legislative party. Now, in this, who is the political party and who can issue validly in law direction to the political party? Unless that question gets decided, there is no ambiguity in that regard. Speaker has no jurisdiction. And that is why the order is that once such question arises, EC will decide first. And that is the writ petition. Ground D and para 36 in rejoinder. Grateful, my lord, I am deeply obliged.
Yes, we did, Nani.
Very brief. I realize the lordship, sir. very keen to hear a detached voice rather than partisan interests. So I'll just state my proposition. My learned friends have dealt comprehensively with the distinct jurisdictions of the Speaker and the Election Commission. One decides disqualification of MLAs in the House. The EC decides intra-party disputes. However, the question of disqualification, and what incidentally I hope to answer my Lord Narasimha's query, the question of disqualification under the 10th schedule is governed by a mandatory procedure. Particularly, there has to be a notice, a hearing, rules of natural justice, and a reasoned order. So there is no concept of potential or deemed disqualification. It has to be actual, however, not a deemed fictional one. The entire case of the other side, trying to link disqualification with intra-party disputes, is based on a disqualification which has never happened. There is no such question of a deemed disqualification. That fiction is the fiction of the other side. Thirdly, allied to this question is that the deputy speaker, in this case, there was no speaker because the then speaker had resigned since 5th February 2021. But the deputy speaker in this case was disqualified from embarking upon the adjudication procedure because it had been brought to his notice that he had lost the confidence of the majority in the House qua his position as deputy speaker. Now, my lord, this is not just Navam Varia's case. This is actually a mandate that when your own position as deputy speaker, i.e., the adjudicator of disqualification, is under question, then it is not just Navam Varia, they amplified it. But it's Article 181 of the Constitution's mandate. And I'm not going to read it out. Your Lordship will just note that Article 181 says this, that when the Speaker of the Deputy Speakers, a majority is itself questioned, he must desist from the adjudication process. So it's not just Navam Varia, which is one of the questions of law propounded. Navam Varia does say so. And we're having a second look at it, but also Article 181. Remember, two more propositions. Yes. Any link, in my respectful submission at the outset, the distinctive jurisdictions of the Speaker and the Election Commissioner, my lord, is determinative of this matter. Now, that's almost conclusive. But my lord, any possible link between disqualification and the powers of the Election Commission to deal with inter-party disputes has been snapped by the very important event of the Chief Minister resigning on the 29th of July 2022. On that night he resigned. Sorry, 29th July. June. Sorry, June. 29th June. I'm so sorry. 29th June. Now, my lord, when that happened, a government fell. Nothing that happened thereafter, after he resigned, was a consequence of what happened previously. When the Chief Minister resigned, what kicked in was a process which was obligatory on the governor of the state. The governor had to then decide whether he could find a stable majority, which in turn necessitated discovering that person who commanded a majority of the House, and that person could therefore offer a stable government. That the governor proceeded to do. And because this is the mandate of Rameshwar Daya of 2007, I'll give us the citation. Rameshwar Prasad. In that judgment, the court said when the governor is setting about the task, and it's paragraph 161 in particular, what you just know, when he is setting about the task, his constitutional obligation to form a stable majority, he has not to be deterred by any questions of potential disqualification. So the governor did that, and a new government came into existence. Now, my lord, when a new government comes into existence, a stable government, one more article kicks in, and that is Article 178. Please see that.
To give the citation of Ramesh Prasad.
Yes. 2006 to SEC page 1. Legislative Assembly of a state shall, as soon as they be, choose 2 members of the Assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the Assembly shall choose another member. Now, on the new government being formed, an election was held for a new Speaker. This was the mandate of 178. A new Speaker now has taken, and he took office after a vote. They participated in that vote and they lost. There is now a new Speaker. Any questions of disqualification? And my lord, the Deputy Speaker only performs the task of the Speaker when the Speaker is not there. Once you have a Speaker, any question of disqualification now goes to the Speaker. There is no need of disqualification, and they want to run away from the question of actual disqualification because the new Speaker has come. So, in short, my lord,
Thank you. Mr. Datar.
Well, just one question of Yasin. But there is a judgment of the division bench, a recent judgment of the division bench, which goes into this between 10th schedule and the election commission. It's a division bench
Of
the Kerala High Court.
what is the citation?
Yes. Okay. It's in the compilation. It's 2021 4 KLT SN 33, page 51. But it's an I compilation and it's judgment number 7 in our compilation of them. Particularly paragraph 76, the last paragraph, is it's the one case which decides both the issues. It's the first case I've seen where both the disqualification as well as the inter-party dispute was concerned, and the impact of each.
Mr. Solicitor, you want?
Sir, only 5 minutes because I appear for the governor. Therefore, my role is different. In my role, I have already played, and if required, I may play. But only question your lordships in the today's hearing required to answer is this. But when Article 324 was framed, just giving a little background, and 5 minutes is broadly outer. When 324 was framed, so there is a beautiful discussion which I will not read, I pass it on, where Dr. Ambedkar examined what was the purpose of 320. And one of the main purpose was that certain political questions may arise as against the constitutional questions. And those political questions, there has to be an authority who, apart from conducting election, will also decide. And that is the election commission. Your lordships would also not possibly be able to go into the political thicket in case of president rule, etc., in a different fact situation which is not arising. The only question, which needs answer for the today's limited hearing is, can your lordships take a call whether this faction is right or another faction is right? That answer, will decide today's hearing. Answer in my respectful submission, no. This is essentially a political question. There are rules framed by the Election Commission of India as to how that question is to be gone into and decided. Because this is not for the first time that such a situation has arisen. That within the party, 2 factions claim that I am the original party. Somebody will have to go into that question. And that somebody, under the scheme of the Constitution, is only the election. Third question, whether both would be overlapping. In other words, suppose the question of disqualification is held against the client of Mr. Kaul and Maninder Singh. Would it have any impact on the exercise to be undertaken by the Election Commission? The answer is no. Suppose the Election Commission takes the call that this faction is the correct faction, represents the original political party. would that have any impact on the decision to be taken by the speaker? The answer will be no, because your lordships are assisted on both spheres. Are here the speaker will decide that whether they voluntarily gave up membership, etc. They would argue that we are within the party, but within the party there is a freedom of speech or expression which we were exercising. That is for the speaker to decide. But even as disqualified MLAs, they would still continue to be members of the political party because there is no disqualification from membership. So the election commission is merely deciding which group represents the original one. So, Manoj, right now, for the limited purpose, my respectful submission, Manoj, is that let the election commission discharge its duties.
Thank you, Mr. Datta. Mr. Datta?
My submission is earlier that the functioning of the election commission is completely different and independent from the role of the speaker in the scope of the 10th schedule. In fact, Lordship sees the 10th schedule. The heading refers to C Articles 102 and 191. Let us first go to that. Lordship just takes 10th schedule. This Articles 1022 and 191.2.
Yes.
And Lord, since we are referring to a state assembly, I will confine myself to Article 191. So, Lordship, Lord, I want to show the constitutional provisions and the statutory provisions which show that the Election Commission's role under the Representation of People Act 1951 is completely independent and completely different from what happens in the 10th schedule. If your Lordship now comes to 191 of the Constitution, Lordship will note, along with the insertion of the 10th schedule by the 52nd Amendment, they also inserted Article 1022 and 191.2. And if your Lordship sees 191.2, a person shall be disqualified from being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. Now, please come to 191.1a. Your Lordship kindly sees, person shall be disqualified from being chosen and for being a member. So, my Lord, there are two types of disqualifications. A threshold disqualification, where you can't even become a member.
And during the
Second, during. But in the company law, they use more elegantly. They say disqualification and vacation. You become a director, then you vacate the office. So when we say disqualification for being, it actually means disqualification from continuing as a member of the house. Now, Lordship will just see A, if he holds the office of profit, B, if he's of unsound mind, C, if he's an undischarged insolvent, and C, D, if he's not a citizen of India and has voluntarily acquired citizenships, etc. And E, if he's so disqualified under any law by or any law made by Parliament. The Lordship will find that there are 4 constitutional disqualifications, which is A, B, C, D. The 5th constitutional disqualification is 191.2. And if your Lordship sees what is 191.1e, if he is so disqualified or under any law made by Parliament, Lordship has to look at the Representation of People Act 1951. I will be basically referring to the Constitution and the Representation of People Act. So, Lordship, just keep these bare accents. Great. Now, if Lordship just sees the index, the table of contents of the Act, of the Representation of People Act 1951. Lord will find that as the Representation of People Act is concerned, see the table of contents, the index will give you also the architecture of the Act. Chapter 1 and 2 talk of qualifications, And my lord will kindly notice that chapter 3 and 4 even disqualification. It's a very small act.
I just, when in order yesterday we said 50, I just told him I had a recollection that I didn't
Yes.
50.
In fact, the statement office and reasons say that 50 act is very short, so we have to expand it further.
Yes.
So Lordship will kindly come to chapter 3, just the headings. Definition, disqualification for conviction, disqualification, ground of corrupt practices, disqualification, etc. And chapter 4 is disqualification from voting, where you are a member but you can't vote. What I'm submitting is the Parliament and the Constitution has consistently made the difference between what are disqualifications under the Constitution and what are disqualifications. As far as the Representative People Act is concerned, the authority to decide is the Election Commission. Actually, I come to 191. The President will decide, but he will take the opinion of the Election Commission. If your Lordship now, so the point I'm making is the disqualification given in the Representation of People Act 1951 is a completely different thing. The role of the Election Commission, your constitutional body, is clearly demarcated, and it is neither hedged nor restricted by the 10th schedule in any manner. So Lordship now comes back to 191, the next section 192, Article 192. If any question arises, 192. And Lord, this is equal to 103. Lord, just makes a note. Parallel provision in Parliament is 103. If any question arises as to whether a member of a house of a legislature of a state has become subject to the disqualification mentioned in clause 1 of Article 191, the question shall be referred to the governor and his decision shall be final. 2. If before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinion. So disqualifications in clause 1, constitutional disqualifications plus under the Act. These are decided by the governor, but he will take the opinion of the Election Commission. Now, and Lordship will kindly note the governor shall obtain the opinion of the Election Commission. So the Act very clearly demarcates the role of the Election Commission as quite distinct, separate, and the parameters are prescribed. Now let's go to the 10th schedule. First see para 2C is original political party. Original political party. But if my lord sees the definition in the Representation of People Act 2F, I learned that I think somebody referred to the rule, but if your lordship goes to the Act itself, the Representation of People Act under 2F, political party. Political party means a political party which is, once again, this opens into the 50 Act.
Mr. Maninder Singh referred to that.
He referred to the rule.
Identical.
Symbol order. Yes, I think in the symbol order it's 2H and here it is 2F. But the point I'm making is the purpose. 2H. Yeah, 2H in the rules. 2F.
2F corresponds to 2H.
Now, it talks of political party means an association or body of individual citizens of India registered with the Election Commission as a political party under section 29 capital A. And just see 29 capital A for a minute. Registration with the Election Commission of associations and bodies as political parties. Constitutional CMROD is not necessary to you have to be a society or a trust. It can just be what we call an income tax, an AOP, or a body of individuals. The association of body of individual citizens calling itself a political party and intending to avail itself of the provisions of this part shall make an application to the Election Commission for its registration as a political party. Now, my lord, my humble submission is the need to call, when you talk of original political party, that means there is something which is original and something which has come later. That must be because of the provisions of Para 3, where a group of people could split and form a separate party. So that could perhaps be the reason why they use the word original political party, which means the political party contemplated and registered under section 29A. That could be the original political party. And Para 3, where they say that if more than 1/3 people split, they could sit as a separate member. And in fact, the 91st Amendment says that this bulk defection is causing harm, and therefore they decided to do away with Para 3 completely. So my suspicion is original political party must be understood to be the 2F read with 29A party. That is the party which is registered with the purpose of anti-defection. They said that even if more than 1/3 members go, it could not amount to defection. That has been done away with. So now basically original political party will now be relevant only in the context of merger, which I will come to later. But for the purpose of us, that's the meaning of original political party. Now what is legislature party? Legislature party means, Lordship sees the constitution. Legislature party in relation to member of a house belonging to any political party in accordance with provisions of paragraph 2 or paragraph 4 means the group consisting of all the members of that house for the time being belonging to that political party in accordance with provisions. Therefore, if the political party is the larger set, then the legislature party is a subset of members of that political party who are also being elected and now form part of the house. It is quite possible that you can have a political party with no legislature party. It's not that every political party has MLAs and MPs. So, legislature party is a subset of the original party. Every legislature member, every member of the legislature party will necessarily be a member of the political party. This is the. Now, coming to the role. Now, what is the question here? As Malad just put it, the batting order. Suppose there is a case of a split in the house in this particular case. Now, I am asking a case independent of any kind of, as a general principle of law, what is the role of election commission? Suppose there is a defection crisis in any assembly or parliament and the matter is sub judice either before the High Court or the Supreme Court. Does it stymie? Does it stop? Does it interdict the functioning of the election commission? Is a question which a lordship has to answer. And my humble submission is, when do we avoid parallel proceedings? We generally avoid parallel proceedings
when the jurisdiction is concurrent.
When the jurisdiction is concurrent, and typically there is a higher forum and a lower forum. And as a general rule, the subordinate forum will yield to the higher forum. So if a matter is pending in the High Court, say for example in a tax matter, and the lordship gives a notice, then typically the officer will not proceed because he will await the decision of the High Court. So parallel proceedings come where the jurisdiction is concurrent, and there is a possibility of possibility of two authorities coming to contradictory conclusions. Second point I would request the lordship to kindly consider. 10th schedule is legislature or member specific. Regulation 15, para 15 of the Simple Order is party specific.
The issue of disqualification would really relate to the membership of that house.
Of that house. That's what why they have to
A
say.
particular state
Yes.
legislature, or if the case may be one
Because,
house in
yes.
parliament.
191(2) says you will be disqualified from member of that house. It doesn't say anything about your political affiliation, political party membership.
Para 15 is really agnostic on
Yes.
the legislature, because
Yes.
that is irrespective of whether there is or there is not any
In
disqualification.
fact, as I mentioned, that political party may not have any member of a particular house also, or it may have members. So what we are concerned is, now if your lordship see the what I call the structure of a 10 schedule, first one is definition, 2 is the substantive, what is disqualification, 3 and 4 are exemptions to that disqualification, that is 1/3 member and merger. So 2 is the bar, the disqualification, 3 and 4 are exceptions. 5 is also an exception where it says that if you're a speaker, it's very unique for a speaker, if he gives up his membership, then when he comes back, he doesn't get disqualified. 6 is the procedure, which came up for consideration in Kyoto Hall. And 7 are the rules. So if a lordship kindly sees, every para in the 10th schedule refers to the disqualification of a particular member. The lordship para 2A, for example. Here is a case where 2A of the 10th schedule. I'm trying to say, Manoj, that the fields are completely different. The territory is completely different, so to speak. Ballot kindly comes to 2(1)(a). A person who has voluntarily given up his membership. Now, Manoj, it is absolutely common sense that if a person is given up his sense, he's now going to file an application in clause 15 of the symbols order. People who come for the symbols order are saying, look, we are in this party, the rival group is in this party. Please decide who's the real party. So 2(1)(a) will never apply. What is 2(1)(b)? You violate the whip. So the role of disqualification is basically a person who gets elected on a particular ticket, then leaves the party and comes to it, then you get disqualified.
The only point really, Mr. Dadar, is that the issue of giving up the membership of a political party within the meaning of 2(1)(a)
Yes.
is not confined to your activities within the house.
Yes. In my submission, Lord, I would submit that will partly depend on, because what I'm submitting is, if a
Because
lordship
voluntarily giving up the membership of a political party is not confined to what you do within the folds of the house. Unlike 2(1)(b), which is votes or abstains from voting in the house.
Yes.
But 2(1)(a) is much broader.
True.
Voluntarily gives up membership of a political
No,
party.
Lord, I'm sorry. I absolutely no
And
problem.
therefore, the speaker's power to determine that is not therefore confined to what takes place within the fold of the house.
Lordship will see there are case laws which say, what is the meaning of voluntarily giving up membership? There are judgments which say, a particular member of party X has attended all the meetings of party Y. He has participated in the functions of party Y. Then has he given up his party or not? So in some cases they say, yes, it's amongst giving up membership. But that's really outside the scope of this reference. That's why I did. So if you say voluntary, Lordship is right. That's why under clause 6, the speaker is called upon to say that Mr. X, he attended the rallies of this party. Not the reported judgments are there, I can circulate them. He attended the rallies of this party. He attended the meetings of this party. He was seen in this particular party. The Supreme Court has said no, but his name is still continuing the register of members, therefore he has not given up. In 2 cases, they said this itself indicates that he has given up his membership. So is it a, I mean, it can be impliedly giving up also, physically actually giving up also. But what I'm submitting is,
But one thing is very clear that 2(1)(a) as well as 2(1)(b) is member specific.
a member specific.
15 is not in that sense member specific. It deals with a faction as to whether a particular faction represents a political party.
Now, Lordship will come.
It refers to a collective group as to whether that represents a political
Now, Lordship will come.
party.
Yes. So, what I'm submitting is, Para 15 basically refers to the collective right, the collective party. Who is the real party? And if your Lordship now comes to Para 15, which your Lordship saw a number of times, I will go through it again. And if your Lordship has seen Sadiq Ali several times, I won't repeat it. But the first 2 paragraphs are very interesting. How did this problem straight away come about? Because Nijalingappa came to the Congress so, and Jagjeevan Ram was Congress. We've all gone through the controversy in those days, the Congress so, the Congress, etc. And then the argument was that the Congress who had majority in the Congress Working Committee, Lordship will kindly just, I'll just give a broad outline of that case.
Sadiq Ali is of which year actually?
1975.
75.
But this
This
took
place
place
was in 1969.
Yes.
We were, so in that sense, Sadiq Ali was doing a bit of a postmortem on what happened.
No, but what happened was because there were more, because Justice Sana remarks in an abnormally prolix order. The prolix itself is abnormal, but his logic says abnormally prolix order of 437 pages. The Election Commission has drawn. There, what happened was, Lordship will just keep up, just 2 point Lordship will know. Sadiq Ali deals with 72 Supreme. Sorry. It's Sadiq Ali says 72 4 SCC 662. Sadiq Ali says the Election Commission went by 2 tests, and that Supreme Court approved. One was the test of majority. Test of majority way Parliament and individual houses. They took the strength of the Congress in the Lok Sabha, in the Rajya Sabha, in the individual houses, and they said that out of these number of MPs, X are in the Jagjivan Ram faction. Y are in the Rajendra Ram faction. They go statewide. But you want to see that, I can show that later. That's the way. Then they say that the All India Congress Committee, working committee, where more than some 2,000 odd members were there, a large majority voted for this particular group. And therefore, the election came to the conclusion that the actual Congress was the Congress J and not the Congress O. And the court said nothing wrong with it because they have gone by test of majority in this. The point is not what we adopt. The point is, Election Commission is free to decide as to how it tests the majority. And by and large, what they're doing is, and I've got cases in my compilation. We had recently problems in Tamil Nadu where who was the correct member of the All India NRDMK. Hearings took place, they came right up to the Supreme Court. And what the Election Commission they take a complaint, ask both parties to give their submissions, then evidence, affidavits, etc. are admitted, and then inquiry is done. Please see my notice under paragraph 15. I'm only submitting that this notice has nothing to do with the election. Chapter. Lordship will kindly see out. Please see the page. See my notice. No, the notice for section 15 notice.
Page 44.
Yeah. Lordship will see paragraph 40, page 44 of R4's compilation, volume 1. 2nd July 22.
Document.
Yes, yes. Document number 9. My lord is gone.
Document number 9.
What is it? What
It's
is
in the
it?
Sadiq Ali compilation.
No. It is the compilation of respondent number 4. Volume 1, respondent number 4, compilation of documents and rules. And this is document number 9.
Notice
Yes.
of 22nd.
22nd, your my lord is right. 22/7/2022.
Page number?
Page 44. So the pages are coming at the bottom.
Yeah. We have got total 118 page.
Yes. Lordship will kindly see the notice is sent to both and then subject so and so. After the preamble, kindly come to para 2. The commission is in receipt of communications as delineated below. She so and so member of parliament and secretary of party on 25/6/2022 intimated the commission about the alleged anti-party activities carried out by some of the MLAs under the leadership of so and so, and objected to establishing any political party using the names Shiv Sena or Bala Sahib. Anil so and so forwarded 3 letters dated so and so, and so he gives the complaint. Then Sri Anil so further email it an affidavit to so and so. Now kindly come to E. Eknath Shinde on 19/7/22 filed a petition before the commission titled that so and so on the paragraph 15 of the election symbols to declare the group led by Eknath Shinde as Shiv Sena and allot the party symbol of bow and arrow to the group. Eknath Shinde, the above petition, I mentioned that. Then he goes on to 1, 2, 3, 4, 5, 6. Now please come to paragraph 3 at page 47. Now this is the standard format we file whenever we get a complaint. We say who has made the petition, what is the gist of this complaint, what is the other side. Please come to para 3. Para 15 of the Election Symbols and Reservation Allotment Order 1968 provide that when the Commission is satisfied on information, your lordship see para 15, I won't read it again. On due consideration of the totality of information available on record with the Commission as summarized above, the Commission of this of the opinion that there are two rival groups in Shiv Sena party, one led by Uddhavji Balasaheb Thackeray and the other led by Eknath Rao Sambhaji Shinde. Each group is now claiming to be the party, and therefore the matter requires a substantive determination by the Commission under para 15 of the election symbols. In order to place both the rival groups on even keel and to protect their rights and interests, and going by the past precedents, the Commission has directed the documents submitted by the rival group be exchanged and the reply written submissions be invited from the two groups. The steps envisaged under para 15 proceedings prior to the hearing rival groups require both rival groups to submit the respective documentary evidence of the support claimed by them, the organizational and legislative wings of the parties. Accordingly, Commission has directed both the groups to furnish written submissions and their respective documents to support their claims by 8th August 20. But when the matter came up, I told the court that this is just the first step. There is no need to stop me. Let all the inquiry go on, inquire the matter. But then the court said, please, furnish documents you asked for. Now, if your lordship sees the notice, it has got nothing to do with the membership of any person of the party or of any house. There is an MP or an MLA. Nothing. Secondly, Lord, by submitting this application by respective sites, none of the provisions of 10th schedule are attracted. 10th schedule disqualification is limited to 218, 21B. So my submission is, as somebody mentioned, para 15 is like the inner party democracy. Suppose as the party grows, there are bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house. So only way election can do is to get a document, get affidavits, listen to the parties, and then decide. Now, Lordship will just see how we have done it in one case from Tamil Nadu. I think that Anna DM.
I don't think we need to go into the issue.
No, what I'm saying is because Lordship will see number of advocates have appeared, numerous documents have been filed, hearing has been conducted. Yeah.
So, Datta, you have already said so in your paragraph 3, the procedure to be followed by the election commission. You have already stated so.
Thank you, Mr.
So my humble submission is not only in this case, but as a general rule, my humble submission is whatever happens on the floor of any particular house of parliament, that will be completely independent. It will not impact the function of the election commission in any case at all. Two things can happen. Either Lordship may allow the petition or dismiss the petition. The result of the para 15 order will be completely independent of that. Whether a person is disqualified or not disqualified. He doesn't cease to be a member of the political party. And we have to go by the majority of the members of the political party, not of the legislature party. The impact of 10 people on the legislature party, but not on the political.
Yes.
Thank you.
Thank you, Mr. Yes, Mr.
My friend is right. These two 10th schedule and para 15 operate in their silos. Then he's right. That's what your lordships have to decide. My lord made a very important and significant comment. A lot of these issues in respect of voluntarily giving up members of the party doesn't happen in the house. You go to Gujarat, hobnob with the opposition. Then you go to Guwahati. From there, you are sending notices. Then you accompany the leadership of the BJP to the governor. All this is not within the house. All this is outside the house. And the speaker will have to consider, for the purposes of coming to the conclusion, whether you have voluntarily given up membership of the party, not the house.
It is because of that you are disqualified. Giving up membership of the party outside the house amounts to disqualification within the house. You can't say one is different from the other. What happens in the house is unrelated to what happens outside the house. The election commission can't say, I'm not concerned with any of that. Number two, Manoj, in paragraph 21B, if you vote against the whip, you will be disqualified not just under 21B, but also under 21A. Once you violate the whip, Manoj, not only have you expressed yourself that you are voting contrary to the whip, you are also saying, I'm no longer a member of your party, but I'm not bound by your whip. That's the constitutional position. With the greatest respect to my learned friends, Manoj, they are completely misled, Manoj, the decision of this court in Rajendra Singh. Let me just give you a notice briefly what it was. The BSC. Joint hands with the Samajwadi. Now, there were 109 members of the House. The Speaker gave notice, nothing. He did nothing. After a few weeks, 24 more of them joined. So they became 37. Then the Speaker said, this 37 is 1/3. And because this 37 is 1/3, therefore they are protected under the 10th schedule, because at that time paragraph 3 was there. This court said no. You have to decide on the day when 13 members went to the Speaker. But at that time, not 1/3. Speaker wrongly allowed 1/3 to develop to give protection to the 10th schedule under paragraph. Therefore, the disqualification relates back to the time when the 13 members of the Speaker. That's one part of it, but the difference is completely wrong. That is unrelated to the issue of giving up membership of the House. When paragraph 3 was, before it was deleted, very interesting. It is integrally linked with the political party. We see our compilation of statutes. What's it? Paragraph 3.
You can read it out, Mr.
Sorry. He says not given to the court. Sorry.
That's okay. And it's not in the footnotes. Otherwise, normally it's in the footnotes. This footnote doesn't have it actually.
I'm sorry.
No, that's all right. Just read it.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction. And you see, Mother, the correlation of this with paragraph 15, which has arisen as a result of a split in the original political party. It's 115 of their compilation. I will look at it. Better one as we did.
You can.
And such group consists of not less than 1/3 of the members of such legislature party. He shall not be disqualified. So what does it say? A member of a house who claims that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. So when the Speaker decides in the paragraph 3, Rajendra Singh Rana says, merely because you make a claim is not enough. The Speaker will have to prima facie decide that there has been a split in the original political party.
It's not a question only of the legislature. And that is reflected in paragraph 37, 36 and 37. You just did 37 because that's why I wasted time with it. But this is 1074 SCC model I have. In their compilation is 192. Para 37. I'm reading 36 and 37. 192 models probably. Two 219, my lords. 219, they are quoting Jagjeet Singh Miller's paragraph 69. The lords, my lord, just that's in italics, not in italics, but in indents. My lords have that. Apart from the above, the acceptance of the contention that only a claim is to be made to satisfy the requirements of paragraph 3 can lead to absurd consequences, besides the elementary principle that whoever makes a claim has to establish. It will also mean that when a claim as to a split is made by a member before the speaker, so as to take benefit of paragraph 3, the speaker, without being satisfied even prima facie about the genuineness and bona fides of the claim, has to accept it. It will also mean that even by raising a frivolous claim of split of original political party, a member can be said to have satisfied the stipulation of paragraph 3. The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We are of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that a claim is made to have a split in the original political party, in addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajendra Singh Rana, they have said we are the original political party is not concerned with the split in the legislature. It's just the contrary. The argument, therefore, that all of the 37 MLAs required to do so was to make a claim before the speaker that there has been a split in the original political party, and to show that 1/3 of the members of the legislative party have come out, and they need not produce any material in support of the split in the original political party, cannot be accepted. The argument that the ratio of the decision and Jagjeet Singh revised to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, what's important here, and this is the significant part. Having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena. I am recognized by the speaker of the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. Para 34 of this judgment, the act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the whip issued to him. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. If it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. What will happen on the 19th of July thereafter has nothing to do with what's happened before, because what has happened before is that they have given up the membership of the party. Let's ask the question, a very important question that we threw him out of the post. But let's see our Volume 2. First, we show the letter to the Election Commission. Now, let us kindly see the letter we wrote to Cindy on the 30th of June. It's much before 19th July. At page 321. Convenience compilation, volume 2, page 321.
Yes,
Dear Mr. Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, Malas, I tell him that you have already by wax given up membership of the party. So it's not a question, Malas, of removing him from the post. Now see the letter we write to the commission at page 333. This is on the 1st of July.
yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackeray in terms of party. just one has mentioned that he was not as per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, Mothers, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which